to just India will be a investor-friendly country. Similarly, so on. And justice, it is my duty to place before the people of the country the thing will chart it out a few issues that initiatives towards ease of doing business, then initiative towards better management of litigation, initiative towards maximum government and minimum governance, initiative towards digital India and e-governance, initiative towards computerization of the courts, initiatives towards justice delivery, and initiative towards access to justice projects, and a few other projects which are taken up by the Ministry of Law and Justice since last 2 years. As far as ease of doing business, that is one of the prime concern of Honorable Prime Minister. You know, speedy disposal, fair disposal of commercial disputes is the need of the hour, because India should be a destination for investors. They should feel that, yes, if I invest in India, if there are some commercial disputes, it will be resolved as early as possible. So, you know very well, Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015 was enacted by the Parliament, and already almost Delhi, Mumbai, Himachal Pradesh, Gujarat, these high courts have already working on these lines, and commercial courts have been established in those courts. Similarly, another important act that has been amended is Arbitration and Conciliation Act 1996. Earlier, everybody wants to have an arbitration not inside India, somewhere, either Singapore or UK or some other countries they used to rush. So we thought that India should be a hub of arbitration. The bill was pending since last 10 to 12 years. It was placed before the Parliament in the year 2003, but it was not at all that amendment bill was passed, and it didn't become the act. So we amended the act and thereby made it very litigant and people-friendly act, and thereby minimum intervention of courts, simplified the procedure, fast-track disposals, cost-effective and user-friendly. All these initiations have been taken, and by bringing an amendment to the Arbitration and Conciliation Act, and by bringing a new enactment by Commercial Courts, Commercial Division and Commercial Appellate Division and High Courts, that ease of doing business in India will certainly, it has geared up. Initiative towards better management of litigation. You know, government is one of the major litigant. So everywhere we want to reduce the litigations. For that reason, we have already a draft national litigation policy is under formulation to make the government a responsible and efficient litigant, wherein we made several policies, that is preventive measures for reducing new filing of cases, avoiding litigation between the government and PSUs, restricting appeals only if it affects the government policy. This type of several initiations, policies have been drafted, and even various stages between the departments, between the government and PSUs, we want to see that the disputes, if any, that has to be resolved outside, and it should not go to the court. So this is under formula. come down. We the office as many as 1,827 absolute and redundant, and we bills have passed. We should that is the exercise. A study report by the National Law School and a ministerial interministerial group has been constituted for consideration. We hope that it will be converged, and nearly 36 tribunals, as per the report that we have received, it will come to 17 tribunals. Thereby, it will give maximum governance with a minimum government. As far as Digital India and e-governance is concerned, already the application appointment of notaries on all they are able to file their applications of notaries online with their supporting documents and all that. E-governance and e-courts usage have started in ITAT, Income Tax Appellate Tribunal, leading to faster disposal of the cases with less hassles to litigants. Similarly, digitization of work of appeals have already begun. We hope that we will complete it within a small period. A web portal, that's one of the important areas. A web portal has been already introduced by name LIMS. It will help each departments to list out their cases, to trace out their cases, and to see that how the cases can be disposed of at the earliest. These are the initiatives towards Digital India and e-governance. Initiatives towards computerization of courts. Phase first was already completed. Nearly 14,000 courts, subordinate courts are computerized, and computerization has begun already. Several high courts, now the high courts are implementing authority. They have already floated the tender, and they are already high courts. This phase 2 project, it will facilitate the litigants, lawyers, and even for court management also it will help. We are going to install touch screen based kiosks, use of e-filing and e-payment and mobile applications, and composite set of services through judicial service centers also. We are going to do it. It will certainly facilitate and subordinate at their. We have over 4,000, 15,300 laptops to the judicial officers. Initiative towards justice delivery, this is the one issue where every day we are hearing news either in the print media or the electronic media. Appointment of judges. We have speeded up the issues. After the NJSC was struck down, the Supreme Court asked the government to give a draft MOP. We drafted the MOP, Memorandum of Procedure, and we have sent it to the Chief Justice for their views. Meanwhile, we thought that it will take some time, so the government wrote letters to the Chief Justice and requested him till the finalization of the new Memorandum Procedure, we will go ahead with the appointments as per the earlier Memorandum Procedure. This year, from January up to last April, we have 51 new judges have been appointed, and another 86 additional judges were made permanent, and we have received about another 170, which is under process. We have enhanced the judges' strength. It is also a matter of concern. Everywhere judges' strength has been enhanced. There is a hue and cry across the whole country. The judges' strength of the high courts has been increased from 906 as on 1/6/2014 to 1,065 as on 27/4/2016. Similarly, the judicial officers' strength, sanction strength has been increased from 17,715 at the end of 2012 to 20,502 on December 2015. Justice delivery is a matter of concern. So the government took an initiative, especially the pecuniary jurisdiction of Delhi High Court has been increased from 20 lakhs to 2 crore, facilitating access to justice within the vicinity of the location of the district courts also. Centrally sponsored schemes for the infrastructure development facilities to the judiciary are taken care of, and subordinate courts have increased considerably in the recent past. More court halls are available than the judicial officers are present. Initiative towards access to justice projects, that paralegal volunteers, we are already appointed about 300 paralegal volunteers in Odisha, about 400 paralegal volunteers of northeastern states, and about 187 paralegal volunteers in Jammu and Kashmir, and have been trained under the activities of state legal service authorities. Legal literacy is another one of the important area that has been taken care of by the Ministry of Law and Justice. That legal literacy has been incorporated into National Literacy Mission Authority, and activities have been started in states, 62 districts in Uttar Pradesh, 31 districts in Rajasthan. Similarly, help desks for juvenile in observation homes have been established in Maharashtra. Legal aid clinics, 46 legal aid clinics have been established in the remote corner of the backward districts of Nagaland. These are the several projects, access to justice, that has been taken care of by the Ministry of Law and Justice. Similarly, other important initiatives, I can say the Lok Adalat is one of the important areas of concern, where we used to settle the matters outside the court. They have given all sorts of assistance to the Lok Adalats. As on 30/9/2015, 15.14 lakh Lok Adalats have been organized since inception, that is right from 2013. More than 8.25 crores cases, including pending as well as those pre-litigation case, has been settled in these Lok Adalats. Nearly 7 crore 46 lakh 29,721 cases have been settled in Lok Adalats since November 2013 up to 2015. alternative dispute resolution mechanism is one of the area where this National Legal Service Authority at the national level, as state level authorities are taking care of. So these are the several enact during the has been taken, and we hope that uh,
Honorable Minister, sir. Now,
no, we have not received it.
yeah.
Sir, the report, Law Commission report given in 1987, which was based on the opinion of some experts and the public. In the report itself, they said that this has to be calculated on the basis of the data sent on scientific manner, but no scientific data was available. Even recently in the Imtiaz Ahmed's case, the Supreme Court itself has asked the Law Commission to once again look into the matter. They again said that it may not be possible unless we get the scientific data. So if I give 2 or 3 small examples, I think that it will be more convincible for you. Sir, this judge population ratio has to be calculated on the basis of the workload. How a case can be disposed of. It differs from state to state. It differs from place to place. All these things has to be calculated. Then only we can come to a conclusion what is it. Say, I will give one example. During 10 years, there has been 17% increase in number of cases instituted in district and subordinate courts. However, during the same period, the sanctioned strength of the judges of the district and subordinate courts has been increased by 42%. And working strength has been increased. See how the in civil procedure code we can give only 3 adjournments. That is not implemented. And in Orissa, in civil matters, 50 adjournments are given average, 32 adjournments in criminal matters. So I think these factors also will work. The huge pendency, of course, I should congratulate the judicial officers, judges and everybody. Since last 2, 3, 4 years, the pendency is decreasing. It is in decline in spite of this huge vacancy also. I should congratulate them. Say, in 2012, in Supreme Court, 66,692 cases were there. As on 19th February 2016, it has come down to 59,468, in spite of, you know, how much before the Supreme Court. As on 31/12/2015, it has come down to 38.70. And I certainly say that as far as filling up of vacancies in the subordinate, as far as filling last 4 judges have been to the Supreme Court. Six working days we have processed. Within 6 working days we have processed the file. At present, nearly 170 names are with us. It has been recently sent. We are processing it. We have to send it to the constitutional authorities, the Chief Minister. We have to get feedback from them. We have to get the IB report. So there will be no delay on the part of the government as far as appointment of judges.
Sir, this side.
One minute, wait.
Sir, sir.
One minute, he has a supplementary, we'll come back.
Sir,
Scientific research, which you said requires scientific research. Are you going for that?
Sir, now already the matter is pending before the Supreme Court. It is sub judice. Already the Chief Justice has asked the court management committee to look into the matter. So they are working on it. After the verdict comes from the Supreme Court, then
That is clear, but that besides the point, do you say that the 40,000 judges which Chief Justice is saying are required by the judiciary in the country is based on some unscientific formula or something or out of fact?
sir, I would like to show a letter to you. This is the letter written by me on 1st January 2016 to the Chief Justice. I have mentioned everything. In spite of the Supreme Court told the government to give a draft memorandum procedure, I went to the Chief Justice and I said, sir, it will take its own time. So you send the names as per the memorandum procedure, earlier memorandum procedure. We will certainly process it. So we did it. Is there any fault on the part of the government?
Yeah, please ask your
sir,
question.
there is a long pending demand for the separate High Court of Telangana. So why it got delayed? What is the status?
Sir, the matter is pending before the Andhra Pradesh High Court. The matter is sub judice. I don't want to make any comments.
Manish.
Sir, recently the Supreme Court collegium, they recommended 4 names, 3 of them Chief Justices. So what is the government's view if seniority is overlooked while recommending the names of Chief Justices for Supreme Court?
Say, ultimately the collegium has to take care of all these things. Whenever the names are sent by the collegium, either from the High Court or Supreme Court, we will process it, getting their credentials by getting the report from the IB report or getting some views of the Chief Minister and all that. Rest of the things, because the NJC has struck down, if NJC would have been there, then we had a right to look into all these matters. Now, the total appointment is rests with the judiciary in their domain.
And sir, if I can also ask a supplementary, what do you think would be the best case scenario for a memorandum of procedure? What
because we have drafted, we have sent it to the Chief Justice. It is in their domain. So after receiving their views, then only I can.
Hi, good evening, sir. Sir, Ashmit from CNBC. So there was recently a lot of conversation with respect to frivolous litigation, especially in the Supreme Court and the higher courts. And towards that end, during the proceedings of one of the cases, the Attorney General had in fact remarked, or rather suggested to the Supreme Court, that perhaps an additional cost to be levied, especially on big corporates who indulge in litigation, especially in telecom matters, etc. And that was in fact, in my memory, it was also reducing the higher the ladder as you move up on that in terms of seeking legal remedy.
It is like the Ministry of Law and Justice. If at all we want to bring a new law as far as that matter is concerned, then only we can look into the matter. As far as the cases before the court is concerned, it is on the dominion of the court. No, I Act. Reorganization Act says the present High Court that goes to the state of Telangana. The Andhra Pradesh is supposed to give the infrastructure and other facilities, financial assistance and others. Andhra Pradesh has to give. Unless and government to force. And apart from that, the matter is already pending before the Andhra Pradesh High Court. So, what steps I can take if I tell it will amount to sub judice?
But the Telangana government is ready to give infrastructure, whatever it may be.
No, Andhra government has to give. it is for sir. No, if the court directs the central government as per the request of the Andhra Pradesh Chief Minister, you go ahead. We are prepared to go ahead.
Any more questions? I think the minister has given a
से सोचें तो शायद हमारी और आपकी जिंदगी में तो निपटेंगे नहीं। तो इसके लिए जब डिमांड होती है तो कोर्ट्स को क्यों नहीं बढ़ाया जाए, क्यों नहीं उनको ग्रांट्स एंड दी जाती है, और राज्यों को नए डिमांड होती है हाई कोर्ट्स की तो क्यों नहीं दिए जा रहे?
Sir,
क्या कर रहे हैं?
practically enhancement of courts in subordinate and lower, that is in the domain of the state government and the state high court. As far as the high court benches are concerned, the proposal has to come from the chief minister of that state. He should say that, yes, I am prepared to give a building, I am prepared to give a land, and I am prepared. We don't have right from Kerala. Ministry of Law and Provisions.
Yeah, you wanted to ask, yes.
सर चाहे एनजेसी हो या उत्तराखंड का मैटर था या लैंड एक्विजिशन था, एक के बाद एक इम्पोर्टेंट केस एक्ट जो है या फिर जितने स्टेप्स थे वो आप एक के बाद एक हारते जा रहे हो सुप्रीम कोर्ट में। आपको लगता है कि लॉ मिनिस्ट्री या सरकार का गलत फैसला था, इसी वजह से आप लोग हार जा रहे हो, या फिर प्रिपरेशन ठीक नहीं थी?
See, whenever a judgment is delivered by the court, the government that verdict for the smooth running of the government policies and other things. If it is not certainly favorable, then we can go for a new law.
Last two questions. 1 minute.
Ordinance, is it another confrontation with the judiciary on the part of the government? And a constitution bench has decided.
My health minister is the right person to answer this.
Yeah, you ask. Yes. Please hold on.
सर, प्रधानमंत्री जी का कहना था लाल किले की प्राचीर से कि पुरानी सरकार ने या पुराने जमाने के जितने भी बेकार कानून हैं वो बनते आए हैं और मेरा काम बेकार कानूनों को खत्म करना है। तो अब तक आपकी मिनिस्ट्री ने इतने बेकार कितने कानून जो थे वो खत्म किए हैं और आने वाले समय में कितने खत्म हो जाएंगे? दूसरा इसी से जुड़ा मेरा सवाल है कि केसों की चलने वाला नहीं। सरकार से लेकर सरकार इस बारे में आपके मेरे दो सवाल है, कानून कितने खत्म किए पुराने, और ये सरकारी वकील और ये पेशकारों की जो
has been identified. Another two enacted by President's rule that about 427 is left with us. We have returned to the nodal ministry. The nodal ministry has to confirm. The second one reduce all. The court management and everything can be seen.
Prashant.
Bachchan.
But with regard, certainly it will not have any connectivity. Investigation is will be done by an independent agency. So things even today.
Now there is
than 250. 255th. Two report on electoral reforms are before us. We have already formed a committee to look into the matter. All these issues are there. Certainly the government is
सरकार
हेलो सर, मेरा दो क्वेश्चन है अलग अलग। सर, एक दहेज उत्पीड़न को लेकर जो कानून बना हुआ है, इसके समाज में बड़े मिसयूज की बातें होती हैं और बीच बीच में खबर आती है कि इस तरह या दूसरे पुलिस थानों में जो जायतियां होती हैं उसके
And a lot of work has been done.